Hello, everyone. This is another episode of the Unisolve Question, and my guest today is Sana Halwani of Lenczner Slaght. Hello, Sana.
Hi, Pilat.
How are you today?
I'm doing great. Thank you so much for having me.
Yes, it's a great pleasure to have you. You're the first Lenczner Slaght lawyer to come to the show.
Oh, I feel very privileged then.
It's really a momentous occasion, and I'm sure that it will be a lot of fun. Judging from the recent Twitter discussion about Apple's Lenczner Slaght is a fun firm, so I'm sure we'll have a fun discussion today.
We do like to have arguments about even the most ridiculous things, like which Apple is best. And apparently we like to do it in public on Twitter. So, the rest of you can have a little fun at our expense as well.
It's always good practice, and when you do it in public, you get feedback. So it's almost like practicing in front of the mirror.
Exactly, it's perfect.
Yeah. I want to start with your origin. It's quite a merited origin. You followed a blue chip path to where you are right now. But I don't think that a lot of people know where you started. Where were you actually born?
Oh, yes, that's definitely at the beginning. I was born in Beirut, in Lebanon. I was born at AUB Hospital, the American University of Beirut Hospital, where my mother actually had graduated from. But so that's where my family hails from. Both my mom and dad are Lebanese.
Wow, that's really interesting. One of the Lebanese people that I really like to read and follow is Nassim Nicholas Taleb, and I'm not going to ask you if you know him.
Don't.
Yeah, I'm not gonna do that, but that's the first name that came to mind when I heard Lebanon. A beautiful country. I really dream of visiting it once or twice. Do you ever go back? Because, for example, I wasn't born in Canada.
We don't go back very much. I've only been back a few times. There are sort of, I feel like, two different types of Lebanese folks, if I can be really categorical, in the diaspora. There's a set of families that came to Canada and then went back every summer, and the kids and the mom at least, and sometimes the dad too, would go back for the entire summer and spend their time in their, with their family, which sounds lovely, but wasn't the way that I grew up. My family loves where they came from, but also really loved Canada and loves Canada and the opportunities that Canada gave, and felt like I feel like my parents just wanted to make sure we were making a life here and weren't just looking backwards. So I did not spend a lot of time in Lebanon when I was a kid. We went back a couple of times while I was still under my parents' roof. And I've wanted to go and take my husband and my children, but it just hasn't happened yet. But that's on my wish list as well.
Do you speak Arabic?
I don't, but I understand everything my parents say. And when the family gets together. So I have a harder time with other, like if somebody's not from Lebanon, if they're from Saudi Arabia or they're from Iran or something and they're speaking Arabic, I will have a harder time understanding, because I really mostly understand the Lebanese sort of expressions and rhythm. But my parents, when I was a kid, used to switch to Arabic when they didn't want us to understand what they were saying. So it was a significant motivator in learning to understand the language. And if you know any Lebanese folks, you know that they don't just speak Arabic, they speak a mix of English, French, and Arabic. So you throw in a French word, mostly it may be the occasional English word. So you can sort of decipher what's happening or what's being said. So I feel very comfortable understanding the vast majority of what somebody from Lebanon would say to me in Arabic. But then that link is missing in my brain and I can't, form the response in the same language, unfortunately.
You used the word motivator when you spoke of your parents. And I can't help thinking about what motivations your parents provided to you, what other motivators your parents provided to you in your path to law. And I know that you started on the path to science. You didn't start on the path to law. I assume you wanted to be a scientist or maybe a doctor. Is that correct?
Yes. So let me give you a bit. It's always an interesting one for folks. There's a lot of us in the IP world, but maybe not that many of us otherwise. So first, my parents were very supportive of whatever I wanted to do. They were definitely not the type to impose their views on what was a good path forward. And we're very happy for all the steps that I took through my academic and professional career. They really are cheerleaders of their kids, myself and my sister. However, science was certainly more in line with what was sort of expected or anticipated, in my family, because my family is chock full of doctors and engineers. My mother went back to McGill and got her PhD in insect physiology. And so there's a lot, my dad is an air transport engineer, although he's an entrepreneur. So there's a lot of understanding of the sciences and medicine and engineering. And I certainly had an aptitude and a love for it as a child, and did, as you noted, Poulat, go into a biochemistry degree at Queen's in my undergrad. And my intention was, at the time, what I was inspired by, maybe not my intention, was the life and work of Louis Pasteur. I, as a kid, was a voracious reader, and I read a biography of Louis Pasteur when I was, 11 or 12 or something. And I read it multiple times. It was just fascinating to me how he had figured out how microorganisms work and where disease comes from. And so I had in my mind that kind of a path. And I had to choose a science, and I went into biochemistry because I liked both biology and chemistry, really. Frankly, didn't really know what I was getting myself into. Knew I didn't really love physics, so avoided that. And so went into an undergrad thinking, okay, I probably going to want to do some research, not a medical intention. Maybe early on I had in the back of my mind, maybe medicine, but I decided that wasn't going to be for me pretty early on. And then ended up at Queen's in a biochem degree. And then realized that I didn't want to spend my life in a lab. And I think that realization comes to a lot of kids and folks who end up in the sciences. A lot of us were pushed. I wasn't pushed, but a lot of kids get told, keep your options open, go into the sciences. I actually get really mad at that kind of advice. I really think you should do what you love. And I loved it, and I went into it. But then the reality of lab work, and I worked in some amazing labs, but the reality of lab work for the rest of my life was not a reality I was willing to agree to. And so decided that I wanted to go into bioethics. So that's, maybe I'll pause there and let you get a word in edgewise, Poulat, but that sort of was my path towards the law.
Yeah, it really interested me how your path started to curve towards law, and your transit point or your midpoint was the bioethics program in the UK, if I'm not mistaken.
That's right.
So you said that you didn't want to spend your life in the lab. Did you have any ambition for public speaking? Did you have any ambition for power, for influence, all the things that law practice gives us? Because I know what life in a lab is like, because I come from a family of scientists myself, and it's a life of routine, of collecting data basically for years and months and so on and so forth. And are you not such a person? Do you have this extroverted ambitions to change the world or to talk to the world or something like that?
Extroverted ambitions, absolutely. I definitely was. I was a debater in high school. I didn't really take it into university so much, but I liked those things. I liked public speaking. I liked debating. I didn't have any real motivation for, I think you said, power and influence. What I actually thought I was going to do, which obviously is not how it turned out, is I wanted to transition into bioethics. I looked at the people at the time who were doing bioethics, and they had done a philosophy PhD, which I did not want to do, or they had gone to medical school, because at that time, bioethics was quite closely tied to medical ethics. It didn't really go beyond that so much. And I didn't want to go to medical school, or they were lawyers. And I said, oh, lawyers, I could get a law degree. Maybe they weren't lawyers, but they had a law degree. So I decided to go into a bioethics degree as kind of a transition point, as you said, and it really was to sort of decide, okay, do I really want to go to law school? Do I want to spend 3 years doing that? And I thought that that 1 year of an arts degree would let me know whether this was a path that I should take. And so I did the bioethics degree in the UK in Sheffield, at the University of Sheffield. It was a very bespoke kind of program at the time. There was really nobody else doing this wider bioethics review, not just medical ethics. It was a very small program, but I had a wonderful time. I had wonderful colleagues and student colleagues and teachers. And then I thought, okay, this is what I'm going to do. And I'm going to go to law school to be an academic in the bioethics area. So that's not an area of influence and power, at least not from what I understand, maybe on the world of ideas, but not in the way that you had described. And so that was my original intent, was to go to law school, get my law degree, figure out if I needed to also get an LLM or otherwise, and become a professor in the area of bioethics. It's not what happened.
Very interesting. After doing dozens of interviews on the show, I've started noticing some patterns among lawyers, and I noticed that quite a few lawyers who clerked at the Supreme Court wanted to be academics. Quite a few, some lawyers who became judges started as academics. I'm talking about Justice Sawson, and he was a guest on the show, of course. So this idea that you wanted to be an academic, can you elaborate a little bit about it? What is it that you like doing? Do you like digging through? Do you like writing? Do you like reading? Do you like synthesizing a bunch of articles? What is it specific? What does it specifically mean to like being an academic or to want to be an academic?
So that's a great question. I'm not sure I really knew what academics did when I had set in my mind that I wanted to be an academic. And by the way, Justice Sawson taught me Civ Pro, civil procedure, in first year at law school, actually. So he's a wonderful, wonderful man. I was so excited to see him elevated. But in any case, I loved the area of bioethics. I thought it was fascinating. I thought it was incredibly important in terms of figuring out what we as a society wanted science to do for us or not do for us when it comes to artificial reproduction, when it comes to xenotransplantation, the use of animal organs in humans, when it comes to straight up medical ethics, right to die, genetic modification, genetic technology. I mean, those are just essential questions about the human condition and what we as a society will agree is a good idea or not. Even if we can do it, should we do it, right? And so that intersection of science not in a vacuum, science and society, was what absolutely fascinated me as a subject matter. And frankly, what can you do with that as a job and really engage with those issues is to become an academic, to write and research and teach in the area, and perhaps maybe this is where the influence comes in, influence public policy in the area as a knowledgeable person, as an expert down the line. So I think that's what I had in mind. I don't think, frankly, that I had thought through what that would mean on a day-to-day basis, on a lifestyle kind of basis. I just thought this is a topic I love, and it doesn't leave behind completely the science education and experience that I've had, which I didn't want to do. I didn't want to feel like I had, wasted my time. And I then said, okay, well, if I marry it with a law degree, I think I can do something with this. So I'm going to go to law school.
Sana, I think your choices were good. And the reason I'm saying this is because they obviously convinced Justice Abella of the Supreme Court of Canada to hire you.
Well, they didn't convince Justice Abella, Poulat. They convinced Justice Yacobucci.
Let's talk about that.
Yes. So I don't know how much people know. I know people know quite a bit about how clerks are hired, but what happens in a transition period is because clerks are hired 2 years before they're going to work, when a justice retires and announces their retirement, often there are 1 or 2 years of clerks already hired. And those clerks get effectively inherited by the next judge. And so I was a clerk for Justice Abella in only her 2nd year on the court. And I had actually been hired by Justice Iacobucci, an absolutely wonderful man. I still can picture that interview. He was just so lovely and didn't make you feel stressed out in the interview, which was so nice. Thrilled to work for him, and I was thrilled to work for Justice Abella as well. Really, didn't know so much what to expect when she arrived, but very quickly figured out that it was going to be a very special year to be able to work in her chambers for a year.
Right. So I want you to talk a little bit more about Justice Abella. She was recently celebrated. Her career was recently celebrated. She retired from the court last year. She was an immigrant. She wasn't born in Canada, just like you and I. So please tell us more about Justice Abella. What was she like when she was in the Supreme Court of Canada? What was it like working for her? Tell us a little bit about that.
Yeah, so she's being celebrated, rightfully so, in all kinds of different ways. And I was just in Ottawa at one of those celebrations and a 2-day conference, and I was asked to speak about her influence on women in the profession. But in terms of what it was like personally to work for her, it was just wonderful from beginning to end. She is exactly as she seems when you hear her speak. She is a warm, wonderful, caring, interesting, vibrant person. And she is like that, whether she's speaking to a group of hundreds or thousands of people, or whether you are sitting with her on her couch in chambers, drinking a cappuccino and discussing a case. She's sharp in terms of her intellect is incredible. She's such a voracious reader that she can draw on all of those influences in her work. She's incredibly hardworking. We joked during the conference about her, the 40th draft, the 41st draft, the 42nd draft. She is meticulous in her writing, and she chooses every word intentionally and carefully and doesn't have any extra words that she doesn't need. So working for her was an amazing combination of just this incredibly warm person, but also incredibly hardworking and incredibly intelligent. And it was wonderful. She also, she married my husband and I. We were married in her chambers. She keeps in touch with all of her clerks. She loves to hear about, if you have kids, we call them her grand clerks. She wants to hear about you, your family, your parents, your kids. When she sees you, or if you write her a note, she's never too busy to write back. So she's just this, one of a kind, really.
And a friend of ours, Jeremy Yapolsky, is another clerk of Justice Abella's. I think he clerked 5 or 6 years after you, if I'm not mistaken.
That's right. Jeremy and I have gotten to know each other a little bit more recently because of all these celebrations. For her, it's been pulling her clerks together from different classes, which has been such a thrill for me, because I think for all of us, you tend to know your cohort, right? Your year of clerks really well. I had a wonderful year of clerks, co-clerks, but you don't get to know necessarily the other years as well, even when they clerked for the same judge. So this opportunity has been just wonderful to get to know him, to get to know a number of the other clerks from different years. Many are in Toronto, as you can imagine. So that's been a really nice side effect of the retirement.
Who are some of the lawyers from your year with Justice Abella?
Who clerked for her, or who clerked?
Yeah, during your year. Who I assume they're lawyers, many of them.
Yes, well, yes.
That's why I said who are some of the lawyers?
So
there are people.
So there are.
Lawyers, right?
Yes, their lawyers. Ryan Dial is one. Ryan is a litigator out in BC. He's like a phenom. He's been at the Supreme Court. I think even a few years after we were clerks for Justice Abella, he was at the Supreme Court for I don't know how many times. So he's done some really interesting litigation work. And he had clerked previously, I think, for the BC Court of Appeal. Another one of my co-clerks, Megan, went into work for the Privacy Commissioner. And as far as I know, I haven't kept in touch with her as much. But as far as I know, she's been working again in privacy policy and government for a long time. And then, in the wider clerk cohort, we have a lot of litigators, some very big names, and then some profs and some people who've gone in-house or who've become, academics, profs, as I've said. So there is a nice kind of wide variety of clerks or professions from that clerk cohort.
There was a debate on Twitter recently about names. And of course, the debate wasn't about names that are easy to pronounce or easy to spell. It was a debate about names that are not so easy to pronounce, not so easy to spell. Adam Dodek of Ottawa Law School wrote an editorial, I think, in the Globe recently, if I'm not mistaken, about this topic and about professional name pronouncers or sayers at award ceremonies or graduation ceremonies and so on and so forth. So when I was, every time I do a show, I usually start, before I start recording, I ask the guest how their name is pronounced, just to make sure I don't make any mistake. You probably noticed I didn't ask you how to pronounce your name. And the reason I didn't ask you is because your firm has this wonderful tool on the website where there is a speaker button next to your name. I click on it and I can hear you in your own voice pronounce your name. So I want to encourage all firms to do that. But if they can't, for example, for technical reasons, LinkedIn has the same tool, and you also have that on your profile. So I also cross-check that your pronunciation on LinkedIn. So that's really something that I want to give credit to Lenczner's. And speaking of that, we recently, and I'm sorry that I refer to Twitter so much, it's just a source of a lot of lore for me personally, and of connection with fellow lawyers. Recently on Twitter, I told a story about Lenczner's. And the story goes back 14 years. When I was doing OCIs, I had no idea how to pronounce Lenczner Slaght. Not just Lenczner, but also Slatt. And part of my excuse is that I wasn't even born here. So, English is not my first language. So what I did is I called Lenczner's main line. And I asked them, and I think no one ever asked them before. So the receptionist was like, there was a pause. And then she just told me what it's pronounced like. And I was very happy because I got what I wanted. And then I posted that story on Twitter, and Paul Eric, of course, a partner in your firm, Paul Eric Veal, said there is a reason why your domain name is litigate.com, not lencznerslaght.com. And also,
That's right.
I mentioned that you have this tool on the website. So it's really interesting how the founder's own personal history affects the culture of the law firm, is what I'm trying to say. And what I said on Twitter, even with a name like Lenczner, that nobody really would know how to write and spell unless they knew you, you can become the most famous litigator in Canada. So it says something about I guess, Canada or Mr. Lenczner himself. By the way, how is he doing?
He's doing very well. I mean, we had the pleasure of having both Alan and Ronald be at the firm, still active until only very, very recently, well past where a lot of people would retire. And it was just, for me, because I only joined the firm in 2017, it was so wonderful to have the experience of working with them and of having their mentorship, even for a short time, because they really are just the greatest example of what the profession is supposed to be, particularly with respect to, mentorship and helping the next generation move up. So they're just, they're who they are. I mean, everybody knows their names, even though, as you said, they're not the easiest names to pronounce. But you can go on our website and hit the button for the firm name as well and hear how to properly pronounce it. And you certainly wouldn't be the first to mispronounce it, but it's nice when people get it right.
You know, when I was looking at your firm's profile, I noticed your headshot. And it's a wonderful headshot. This is another thing about Lenczner's. You have amazing headshots, and I think you have a great marketing team because your headshots represent a certain brand and identity. I can see that some thought was put into how all of that was designed and implemented. But as I was looking at your law firm profile photo, I saw a person who was thoughtful, who was careful, who was intelligent, who was skeptical. So those are the things that I saw in your profile photo. And I think those are also the characteristics of a good lawyer. Do you think you are the quintessential litigator?
Oh, that's an interesting question. I haven't been asked that one before. I don't think so. I think I'm a pretty good litigator. I hope to be anyway. I certainly didn't have the path of a traditional litigator or the quintessential litigator, whoever that is. And maybe I can pause here and push back against your premise, Pula, that there is such a thing as a quintessential litigator. Because maybe there was like 100 years ago, maybe. But I don't think there is anymore, because if there was or is a quintessential litigator, frankly, they're probably a straight white guy. And that's certainly not what we see now. The top litigators in the country include a wide diversity of folks who come from different backgrounds, different educational backgrounds. You know, myself with my science background, that's certainly not quintessential. If there was a degree that was quintessential, I think it would be poli-sci, you know. And so I think that litigators have some common threads. You really, you know, you can't hate to public speak, for example. If you hate to public speak, you should probably come up with a different career path for yourself. But even that, you don't have to be a brilliant public speaker to start with, because that can absolutely be something that you're taught. I think there, as I said, so you have to like it. You have to want to analyze and be skeptical, because you need to ask a lot of questions all the time. Although I would say that about a lot of lawyers, not just litigators, you know, questioning, querying, is this the right answer, trying to do better. Those are all, I think, marks of folks who have been successful. So I'm sort of avoiding sidestepping your question here, but I think I have some of those traits. But if there is a quintessential litigator, I'm not sure that I would fit the mold.
Well, you're definitely intelligent. And the reason I'm saying this is because there was a poll on Twitter. And sorry again for going back to Twitter. The poll wasn't about you. Don't be scared.
I hope not.
Is Sana Halwani smart? Yes, no. I don't know. No, I posted the poll. A Twitter poll on Twitter in February this year. And the question on the poll was, which litigators are the smartest? I often post polls on Twitter, and usually they attract 14 to 20 votes. I have quite a bit of followers actively engaging with my tweets, but polls, maybe not so much. 14 to 20 people usually vote. So I think this poll struck a chord because 128 people voted in this poll.
Wow.
And the answers to, or the possible options, the options in this poll were commercial litigators, personal injury litigators, class action litigators, and patent litigators. So I have to tell you that patent won, and with 32%. 32% of people who voted said patent. 30.5% said class action. Only 20.3% said personal injury. And to my chagrin, only 17.2% said commercial. And that's me. So I fall under the least smart category according to that poll, but you fall under the smartest category according to this poll. Do you agree with
I don't agree. And I think all of my colleagues, most of whom would characterize themselves as commercial litigators, would vehemently disagree with this poll. I think that the reason you got that result is because there's something when people think of a patent litigator, for the most part, they think about people who have had a scientific or a technical background. And there's something, I suppose, special about being a bit of a polymath, about being able to do both scientific type of thinking, whether it be, in the biological sciences, chemical, mathematical thinking, whatever it is, and also be able to translate that into a case, into the law, in a way that can be understood by a judge. We don't have juries, so by a judge who may not have any of that technical background. So I think the reaction you got from your Twitter poll is really this reflection that patent lawyers, many, if not most of them, do have some kind of technical background, and there's a perception that somehow that sets us apart from perhaps some of our other colleagues. I have many colleagues who also have a technical or a scientific background and who are not patent lawyers. So they also share that trait with me. But I feel like that's why you got the answers that you did. I did find the ranking quite surprising, the other ranking of the class action and the personal injury and the commercial litigation. That's an interesting one to me, probably more than the patent side.
Maybe it has to do with the composition of my followers on Twitter.
Maybe. Self-selecting.
Yes, I didn't vote. I can't vote in polls that I create. That's the Twitter rule. So a very nice dog behind you.
I was going to say, I think I thought I closed my door. This is my dog Matilda. She's an Australian Shepherd. So everybody, she is beautiful and she's wonderful to have around. So maybe a fun intrusion then.
No, don't worry about it. I really love it that she's here. Now, to go back to the intelligence of patent lawyers, so the way I see it, any litigator has to deal with facts and law. And for most litigators, facts come from ordinary life, even for commercial litigators. What's the most technical thing that commercial litigators can deal with in terms of facts? The thing about patent litigators is that facts are not ordinary, at least in part, or some of them. Facts are scientific facts or technological facts, design facts, right? Engineering facts. And we all know how to work with experts. And expert evidence is sometimes a small part of a trial, sometimes a big part of a trial, but isn't a patent trial all about some scientific or technological area of expertise? Tell us how patent trials are different from commercial trials.
I think you've hit the nail on the head. I think the biggest difference is that although there are many areas of the law where you would require an expert, when it comes to patent cases, for the vast majority of them, the expert will be the core of the case, and you will win or lose on your expert evidence and on your cross-examinations of the other side's expert evidence. And the fact witnesses tend to be a little bit secondary, not always. I mean, again, in a patent case, you're talking about two big areas. You're talking about whether the accused product or service infringes the patent. There's a lot more, I would say, facts that are important there. And then you're also talking about whether the patent is valid or invalid for a whole host of reasons. But even on the infringement side, where the facts play more in, it's the facts as filtered through the expert, whether through testing or observation or otherwise. So the experts end up being the absolutely most important part of these cases. And I think that does distinguish the cases and the trials from what you see otherwise. And the other way that you can sometimes distinguish patent cases is they tend to be very big, like in the sense of big teams, a lot of money thrown at them. They tend to be for very important parts of the party's business, because you wouldn't be making it all the way to trial if they were only about small areas. They tend to be about technology that is core to the parties' businesses that really is going to make a big impact depending on what the outcome of the case is going to be. And so, patent litigators, myself included, have the great benefit of being able to work with like fairly large teams, which can be, it's just fun, right? You get to work with your colleagues, you get to feel like you're pulling together, you're not alone, that you've got people that you can rely on, and you get to be paid to learn about an area of science or technology and from the world leading experts. So your client is paying the expert and paying you, and you get to sort of learn this new area. I mean, it's a real luxury and privilege of being a patent litigator that we are in a position to do that kind of work.
I'm really curious about what you said when you distinguished fact witnesses and expert witnesses. And when you said that fact witnesses play a relatively minor role in patent trials, and it's really all about expert witnesses. But before I ask you about that, I wanted to make sure that I understand the patent trials and the role of expert witnesses. Is it fair to say that medical malpractice trials rely on expert witnesses to the same or similar degree as patent trials, or are patent trials complete outliers that are not comparable to anything?
I don't know if they're complete outliers, but having and practicing with folks at my firm who have both done patent cases and medical malpractice cases, who would be better placed to answer this question. But my impression is that the answer they would give is that it is even more so important, the expert evidence in a patent case compared to a medical malpractice case. But maybe not so far as to call it an outlier, right? I think they might be in a similar area, but still more so on the patent side. And so I do think that there is still more importance, again, I've never done a medical malpractice case, but if you think about the plaintiff, their testimony is going to be really important and really critical, even though there's obviously a very, very key role being played by the experts in terms of interpreting what happened, what didn't go right, what went right, from that perspective.
Do you think that fact witnesses are on the way out in civil litigation? And let me explain this thought a little bit. So first of all, in patent trials, which is a specialized area of practice, of course, you said that fact witnesses play a minor role. But speaking generally, in commercial litigation, or in commercial litigation in particular, trials are document driven. And I think patent litigation and patent trials are also document driven when it comes to many questions of fact, but they're also expert opinion driven, which is a completely different type of evidence. So experts provide opinion, they don't provide any evidence of fact, they provide evidence of opinion, or they provide their expert opinion. So we have as our society becomes more complex, and as our society relies more on technology on one hand, and as our society documents itself more and more, as more and more things are documented now in society with text messages, emails, surveillance video, whatnot. Do you think that fact witnesses are on the way out? So I was watching the Cineplex Cineworld trial on the commercial list. Not all of it, I'm not that nerdy, but I watched some of it. And counsel were doing something very standard. They were taking the witness through emails. So I assume that authenticity of these emails was not in dispute. And I understand that counsel is essentially telling the judge about the contents of important emails through the mouth of the witness. But do we really need to use witnesses for that? I mean, that's kind of awkward and expensive and risky. Of course, someone can say that, well, that's what summary judgment motions are for, and then we saw the rise and fall of summary judgment motions in Ontario, maybe in Canada. So I think our justice system is ambivalent about summary judgment motions. So do you think, with, pardon my long-winded introduction, do you think the fact witnesses are out in civil litigation? Or do you think I'm misapprehending this?
I don't think they're out. I think that there is a recognition in all courts, including the federal court for patent actions and, you know, commercialist and other similar courts doing highly complex, trying highly complex cases, that the vast majority of factual disputes can be resolved prior to the trial and can be presented at trial, because you still need to prove your facts, in a way that is streamlined. And so that includes joint book of documents where the authenticity is not in dispute, so that such documents, you can come to an agreement that documents can be entered as evidence without the need for a witness if there's an agreement on that. That means, we all have robust discovery, and there are clear, it's going to be clear pretty much for most things which way the facts are going to come out at trial based on discovery testimony. So requests to admit can be used so that you get clean admissions on factual issues, agreed statements of fact, apart from the joint book of documents. And then at our court, what we're seeing as well is for some types of cases or some types of witnesses on the fact side, that their evidence in chief will go in by way of affidavit. So that there's still an opportunity to cross-examine, but that we can streamline the trial time in a way that allows for very complex cases, for example, in the federal court, to be determined in only 10 days of trial. And so I think that when there is a true factual dispute, which I think happens more in commercial litigation cases, honestly, than it does in patent cases. Because in patent cases, as I said, you've had tons of discovery, then your experts have had to take those facts and provide you opinions with them. And so there's a feeling that the facts are kind of already there. But in either case, what I think we're seeing is a desire by the court and counsel and the parties, to some extent, to streamline the amount of trial time that's needed, and to allow for different ways for the court to get the facts that the court is going to need to actually come to a conclusion, without having to have weeks and weeks of fact witnesses. Not all cases, but a big chunk of them. You can streamline that fact side of things in a way that allows us to reduce the burden on the court system.
As I'm looking at your law firm profile page, and I keep going back to your law firm profile page, I really like it. There is a quote there about you from IAM Patent 10,000, which I understand is an industry ranking. And the quote says, "A tenacious litigator, highly respected by the judiciary. She lets her legal, technical, and advocacy skills speak for themselves." So I want to talk about everything. There are no questions about anything in this quote, except I'm really interested in the highly respected by the judiciary part. And I don't want to apply it specifically to you. I want to have I want to ask you a general question. What is the role of respect that the judiciary has specifically for the lawyer? What is the role of knowledge and of reputation that the lawyer has with the judiciary, of knowledge of the judiciary or by the judiciary of this lawyer? What is the role of the reputation of the firm in adjudication of cases, in administration of justice? And do you think there are any issues of fairness where a lawyer with great reputation or from an extremely reputable firm is on one side, and an unknown lawyer, completely unknown lawyer, is on the other side? And I know it doesn't happen in patent cases, right?
I mean, a version of that can happen in patent cases, Poulat, right? Because you might have a 8th-year lawyer arguing something on one side and a 30-year lawyer arguing on the other side, in any case, not just patent cases. So I think that there is a concern. I think that if we lived in a perfect world, whether you were known or not by the court, maybe I'll put it that way as opposed to reputation. I'll come back to reputation in a second, but whether you're known or not by the court would have zero bearing on the likelihood of success you're going to have in front of a particular judge or a bench of judges. Because it shouldn't, we wear robes for a reason. It's not about us. It's about the law. That's why I actually like robes. It's about the law and the argument and the facts. I mean, it's about all of those things, and that's what it's supposed to be about. And it's not supposed to be about the lawyer. Now, we wouldn't be where we are as a profession if it didn't matter who your lawyer was, right? So I'm not suggesting that we should have like robots give oral argument or something, right? To like level the playing field or anything like that. What I am saying is that there's probably an over reliance because we're all human and so are the judges on reputation or knowledge of a particular counsel when they're before you. And the way it manifests, in my experience, is not that you're going to win or lose, right? Like I would hope not, okay? Maybe that would be a very bad outcome, right? But in how much a court will give the benefit of the doubt to a counsel, for example. So that's where reputation as opposed to just knowledge. So if you have a reputation with the judiciary, where they've seen you enough times that they know, it's not about having seen you that many times, it's that they know that you give honest answers, that you don't try to pull the wool over their eyes, that if there is something that is problematic in the case law, that instead of pretending it doesn't exist, you actually address it head on. If you have that kind of reputation, which I hope is what's reflected in the quote that you read at the beginning of your question with the court, then that does play well for you. And that means that the court, when you speak, when you give your argument, can be confident that you are being fair and honest with them. And so they can take your argument at face value. But your argument still is what will win the day or not, right? So we all know that fantastic lawyers lose because the facts and the law are not in their favor, and not because they did a bad job, right? Or because the court didn't think that they were a good lawyer or that they had integrity. And so, I think it is important. It becomes easier as you get more senior. It's harder when you're a more junior lawyer up against more senior lawyers. I'm kind of in the middle now, but for most of my career, the person on the other side has been more senior than me. I think that's about to switch. And so it can be frustrating sometimes as a woman, as a more junior person compared to other members of the bar, to feel like the court is kind of letting the other side tell them stuff that's not true because they're more senior. So you see both sides of it. You see that there's a reasonableness to the court giving the benefit of the doubt to lawyers who they trust, but you can also see it play badly when perhaps that trust is misplaced.
This is a great answer. I have one last question for you. What is your big goal for the next 10, 20, 30 years in your professional life? Where do you want to be? What do you want to do? Where do you see yourself?
I really don't know. And I want to be where I am. Like, I'm very happy where I am. I want to be at Lenczner Slaght in that kind of a way, like a big picture kind of a way. I like the work that I do. And I have no plans on going anywhere right now. But I also know, and we've talked about my path a little bit, that I did not have a straight path, that one of the features of my career is that I've taken the opportunities that have been given to me, and that I haven't necessarily had a grand master plan all the time. And it's worked out pretty well so far. So I have a wonderful team. I have wonderful colleagues. I have a wonderful firm. I'm building my practice. I'm really just hitting my stride because you know how long it takes, Bulat, right, to kind of get there in this space. And I would like to keep doing that. I very much enjoy also, working with my colleagues on things inside the firm. And I'd like to continue to do that. And so all the things, Bulat, that's what I want to do. I don't have a holy grail or a prize at the end that I'm reaching for, right? At least not right now.
Sana, I really enjoyed this conversation. Thank you so much.
Me too. It was wonderful. Thanks again for inviting me to be part of this.